So good morning, everybody, and welcome to this first panel on human rights. I'm really honored to share the podium with two distinguished people, Professor Nedelsky and Professor Whitty. But first of all, let me introduce myself, because I assume that I'm not known either. And I'm not sure either what is the capacity that I was invited here, professor of law, constitutional law, European law, member of the Constitutional Court, or more likely, simply a friend of many of the people, of the organizer, and a good friend of the New York encounter. Our topic today is about human rights, something that was already in the scholarship and in the reflection of Professor Nedelsky and Professor Whitty. Professor Nedelsky teaches at the University of Toronto and previously in Princeton. Her scholarship have been concentrated on feminist theory, legal theory, American constitutional history and interpretation, and her most recent book, the title of which is Law's Relations, was awarded an important prize, the Macpherson Prize, and it was that reading that book that we were very interested in understanding her interpretation of human rights and the human face of the person that bears this right. She has a number of academic positions, but I want to stress here that she is also mother of two sons, Michael and Daniel. Professor Whitty is a world-renowned scholar of legal history, and his scholarship has dealt with marriage law, religious law. He is the director of the Center for the Study of Law and Religion at the Emory University, and he edits a number of book series, among which Law and Christianity, Study in Law and Religion, Religion, Marriage and Family. He also has two daughters and three grandchildren. So let's start to introduce our topic on human rights, individual rights or constitutional rights. This instrument of the legal order have a glorious history. Difficult to really decide what is the origin of them, but for sure, after World War II, they flourished as a reaction to the wrongs of the totalitarian regimes in Europe and elsewhere. Let's just recall the Universal Declaration of Human Rights in 1948. And indeed, they have greatly contributed to protect individuals, the weakest persons, against all forms of oppression and despotic exercise of power. Over the last 20 years yet, in Western countries, the rights talk has become more insistent, almost overused. Every personal and social need and desire is claimed as a right. In a way, we can say, using the word of Norberto Bobbio, a prominent Italian political philosopher, that we are in an age of right, or an age of new rights. We often speak, for example, of a right to a clean environment, right to health, right to marry, right to a house, right to live, right to die, right to have a child, and so on and so forth. Rights have become a common currency of every public discourse. So, my first question to both our speakers would be, why are rights so successful? What is their added value? why do we need, in the end, more rights, if any? Professor Nedelsky.
Thank you. It's a great pleasure to be here. So when we think about why would we need more rights, I want to start with the question of, well, what is it that rights do for us? So calling something a right highlights what values are of primary importance, what values stand out for special consideration and weight. That's the first thing they do. Then legal rights, especially constitutional rights, provide a means for holding democratic decision makers, like legislatures, accountable to those core values. Rights are a way of saying that when core values are threatened by government action, the decision makers can be required to justify those threats, to explain why maybe they don't really harm the core values, or why they might be justified in any case. As in the Canadian Constitution, we say if you can justify them in the terms justifiable in a free and democratic society, then it can be okay to interfere with rights in some cases. But to call something a right, a legal right, a constitutional right, is to say that it's not enough just to support a policy by saying it's what the majority wants. And that's a very important contribution of the idea of rights. So then the question of new rights, why do we need new rights, is a question of new values or new recognition of their importance. So for example, as people come to see their relationship to the earth, not simply as an instrumental one, where the earth is something from which individual property owners can extract whatever they want, whenever they want, but instead a relationship of responsibility and care that is consistent with a respectful relation to creation. Then people may start to talk about a right to clean environment as a way to express the priority they want governments to attach to care for the earth. It's a way of holding governments accountable to that value by saying that majority rule is not enough. Or perhaps also a demand to rethink what we mean by property rights. Now, I will say that it's an open question in my mind whether the language of individual rights is the best way to express such a relationship of care and responsibility toward the earth. But the problem is that rights is the almost universal language to attach a priority to value. So that's the language people reach for when they want to bring attention to a value that has not received enough protection. And the language of a right to a clean environment can lead to rethinking of other rights, such as property rights, and bring in a greater degree of responsibility into the meaning of those rights. When rights are understood in relational terms, even individualistic sounding rights can bring an attention to interdependence and to the core values we really care about. And finally, because rights language is used all over the world, I think it's more helpful to try to think about the best way to understand rights, the best framework and language to use to analyze the debates about rights, rather than to try to reject the use of the term.
Thank you, Professor Nedelsky. So rights bring more attention to the values that we consider important in our social life, even when the majority does not pay attention to them. So when majority rule is not enough. What would you like to add, John?
Well, first of all, I want to add a warm word of thanks to Professor Judge Marta Cartabia and for the organizers of the Encounter series for having us here. I want to thank Professor Nedelsky for stealing my thunder because I was going to say much of what she just said. And so I'm going to play to my proclivities as an historian to suggest to you that this business of trying to articulate aspirational rights is a normal part of the rights tradition and indeed has been in the West for nearly 2 millennia. And the question of the aspirational right that is set forth is like a spring tide that comes through and seeks to break new ground, and inevitably that tide recedes. And the question of the resilience of those rights turns on some of the questions that Professor Nedelsky raised to the table. I'd just like to take you on a quick historical tour because we've been doing rights in the West for an awful long time. Back in classical Roman law, we had plain, uncontroversial rights to property, inheritance, and marriage and commercial relationships, and we also had aspirational rights, especially the rights that Christians were pressing for freedom of conscience and the right to free exercise of their faith as minorities who were persecuted and beleaguered, and those rights eventually became actualized in the Edict of Milan of 313. In the medieval canon law of the High Middle Ages, we have the Catholic Church start with a powerful aspirational right to freedom of the church, libertas ecclesiae, to break it free from secular control and authorities, and ultimately, when it received its freedom, having the opportunity to implement a complex medieval canon law that had a whole latticework of public and private and penal and procedural rights for all of Christendom. And secular institutions along the way did the same thing. Remember, this is the 800th anniversary of the Magna Carta, with the first rights of due process, the first rights about property, the first rights of taxation in the common law put in place. In the 16th century, the Reformation broke out in the name of freedom of a Christian, an aspirational norm, which Protestants in their day sought to put in place to overcome what they perceived as the tyranny of church and state, and tried to put in place a secular rights apparatus with countervailing conversations made by the Salamanca jurists in Spain, who developed a very rich understanding of rights for the church and for the state and set forth aspirational rights, such as the rights for the Indians. It is a telling anecdote that in 1650, every one of the rights that would appear 150 years later in the U.S. Bill of Rights or the French Declaration of the Rights of Man and Citizen had already been defined, defended, and died for by Catholic and Protestant Christians. And again, as Professor Judge Marta Cartabia says in 1948, with the devastation of World War II visited on all of humanity, the recognition to again set forth a aspirational declaration of rights. We have been doing this business of trying to define new rights as part of the Western legal tradition from the start. And I think the question becomes, how do those rights become implemented? What makes them resilient? How do they ultimately soak into the polity in a responsible way? And I suggest three quick things. One is that those rights claims ultimately have to be solidly grounded. They cannot just be a whimsical, subjective wish list. They have to be grounded in some aspect of fundamental human nature, in moral duty, in the common good, or something else that gives it resilience over time. Secondly, that right has to be practically feasible over time in the legal culture and social condition in which it has been implemented. It could be a high-flying right like due process of law or equal protection under the law that takes a long time, but it has to be something practical. It has to be something that the institutional and social and cultural condition can accommodate over time. And third, it has to be properly directed, not just as a wish list that the state can fulfill, like a Christmas list, but it has to be a right that ultimately is woven into the community and draws upon multiple institutions to be implemented and made real. The relational theory of rights that Professor Nedelsky is going to talk about, I think, will come out in this. And that there are, as we have in our subsidiarity theories in the Catholic tradition or sphere sovereignty theories in the Protestant traditions, we have a recognition that a variety of institutions beside and alongside the state are in the business of vindicating the rights claim that's made. And the right of a child, say, begins in the family, begins with his or her parents, begins in the communities of which they're a part, long before the state gets involved. Resilience turns in part on multi-institutionality. And so, I wouldn't be despairing of new rights talk. I would simply say that over time, that rights talk is going to have to prove its resilience through some of these factors.
Thank you very much, John. So thank you for this overview of the long history of human rights that starts long before World War II. And this long history proves in itself the importance of rights. And no doubt that one of the more relevant benefits of the rights discourse is that they put the individual in the center. Thanks to human rights, the person becomes a subject as opposed to an object of public choices. she becomes a protagonist of public life. And this is evident in the new wave of European constitution born out of the World War II, where the person, the human being, is the center and the core around which all the institutional structure is built up. But my next question, that is very related to the general title of this New York encounter, would be: what kind of person is implied in the rights talk? Who is the rights bearer? What are his and her personal traits? And I would like to add a word related to the new rights discourse, because the new rights oftentimes comes from a process of fragmentation, especially those that are a result of the principle of non-discrimination tend to capture a single feature of the human person and to insist only on that feature. Principle of non-discrimination in Europe, for example, generated the rights of women, the rights of the LGBT person, the rights of Roma, the rights of migrant people, the elderly, the migrant workers, the indigenous people, the disabled people, and so on and so forth. And the result is a sort of scattered image of the human person portrayed on the basis of a single, although relevant, feature of her identity. So, considering this trend of new rights, what is the human face of rights, and what should be the human face of the rights holder? Maybe John want to start first? Difficult question, right?
How many hours do we have? Well, I'd say the face of human rights is every person who is a creature of God, and every person, as the Vatican Fathers say, who has rights flowing from his or her very being. And so the human rights bearer, the human rights claimant, is not only the rational, calculating adult that we learn about in Political Liberalism 101, but it's also the mentally disabled and the persons who have lost their capacity to reason. It's the sick and the dying and the comatose who have lost their capacity to calculate. The human face of human rights is not only the adult, but also the child, the babe in arms, and in my view, also the babe in the womb who is viable. It's not only the man, but it's also the woman. It's not only the native, but also the immigrant. It's not only the neighbor, but also the stranger. Not only the friend, but also the enemy. Not only the citizen, but also the criminal. Every person, qua person, is a rights bearer and has rights flowing from her or his very nature. And I think that's fundamentally what our rights framework has to start with, and that's what's rooted in the concept of human dignity that the Declaration articulates. But I think it's also important for us to realize that in the 20th and 21st century, what's equally critical is the rights of the group. And the rights of groups, the rights of the church, the rights of the family, the rights of the corporation, the rights of the union, the rights of the school, the rights of a number of different voluntary associations is an equally important part of our rights discourse, particularly since it has become so pervasive. We have various ways of thinking about the group as a rights holder. Classically, it was an extension of the church or an extension of the king. And now we view the person as a fictitious person when he or she comes as a corporation. And the notion that, or as a group, but then the idea is that a group has legal personality, and that legal personality is respected, and the rights for that group to operate as a group are critically important parts of the protection that is accorded to the community that respects human rights. And that's a particularly important issue for people of faith who find in the world today that basic corporate rights of a religious group, including the Christian church, to exist is not something that one can assume automatically. We have 198 independent nation states or territories around the world, and in more than 75 of them, legal personality for religious groups, including churches, is deeply contested. and the ability of that church to exist, to hold property, to maintain standards of entrance or exit, to publish literature, to worship, to be able to engage in relationships with their fellow believers at home and abroad are deeply contested. And so part of the human face of human rights is the collection of people that gather in bodies, which bodies themselves take on a corporate identity which needs to be respected equally well in a human rights world.
Thank you, John. Jennifer.
Thank you. So I'm going to try to pick up on one of the issues of the practicality of rights. What makes them real for people's real lives? And so I think of the what's sometimes called special rights of the disabled, of the elderly, actually as tools for paying attention to the human particularity of every person, of seeing that context always matters for making rights actually available to everyone. The rights of the disabled, of the elderly, of women, bring attention to the embodied reality of the rights holder. The person with rights always exists in a particular body, in a particular context, and we cannot know how to make rights real in a practical way without paying attention to these dimensions of human reality. Of course, we can and should invoke big abstractions like equality and dignity, but we can only know how to make those abstractions real by paying attention to the concrete particulars of the people whose rights we are concerned with. I think some frameworks of rights, like those that take social and economic and cultural rights seriously, are better suited to paying attention to these concrete particulars. When one is used to asking whether a given right, like, say, the ability to participate equally and effectively in a democratic process, is itself dependent on a certain level of economic equality, then one develops the capacity to pay attention to context and the particulars of human needs and abilities in trying to figure out how to give rights practical meaning for all. Some structures of rights are more likely to give a fully human face to rights, even as we also ask ourselves whether these rights must be understood not simply in human terms, but in relation to the wider creation with which we share the earth. So while special rights, like the rights of the disabled, can be misused to make disability, say, that single feature of the person, the center of a person's identity, that's a downside of this focus on special rights. They can also be understood in ways that highlight the vulnerability and interdependence of all people, and to structure our mutual responsibility accordingly. I think the United Nations Convention on the Rights of Persons with Disabilities is a good example of this approach to particular rights. So while there can be bad consequences of a proliferation of special rights, if we approach them from a relational perspective, such rights can turn our attention to the necessary specificity and context that can make rights real for everyone.
Thank you. Thank you to both of you for recalling us the complexity of human experience. The rights bearer is not just an individual, is also a group, and a person that lives in his body, in his practical reality that deserve attention and special rights in order to be taken into consideration. But let me insist a little bit more on this point of the idea of the person that is implied by the rights talk. And let me start with a quotation that's a little bit provocative, a little bit thought-provoking. Speaking about the European Union, Joseph Weiler says that the insistence on rights, at least in Europe, I don't know about American continent, but probably it's the same, has put, quote, the individual in the center, but the result is a society of self-centered individuals. So that the result of the insistence on rights is an excess of individualism, narcissism, selfishness, And these are costs that our society are paying for this insistence on rights. Rights turn human desire and needs into claims. And each claimant has a defendant in front of him. So my next question to you would be, do you think that rights inevitably produce or encourage a conflictual society? Or do they encourage to break relationships? Or do they shape relationships as litigations?
Okay, so as I see it, what rights actually do is shape relationships. Now, those relationships can be conflictual ones. They can be highly individualistic. Depending on how rights are understood and implemented legally, they can turn our attention to reciprocal obligation and the realities of human interdependence, or they can highlight individual entitlement as if it had no consequences for relationships with others. It's not rights as such that determine what sort of relationships and thus what sort of values will be fostered. It's how we define particular rights and whether we develop a relational habit of thought when we engage in debates about rights. When people see that rights always structure relationships, say of power, of trust, am I doing something?
Yeah, no, I don't know.
Okay. Rights always structure relationships, say, of power, of trust, of responsibility, or lack of responsibility. Then the question is how one wants rights to structure relationships, and in order to foster what values. For example, the relationships fostered by no-fault divorce, should we see them as providing vital freedom of choice without destructive patterns of blame? Or are those relationships also free of norms of commitment and responsibility? Is there a way for the rights created by family law to foster both freedom and responsibility? Or in a different context, does a factory owner have responsibility to her employees when she's thinking about closing the factory? Should our rights of property include such responsibility? Or should we say that the relationships created over 20 years of production play no role in the individual rights of the factory owner? The question is not whether there should be property rights. The question is how we should define those property rights and what kind of relationships will follow from that definition. What values, say, equality, responsibility, attention to community, freedom, entrepreneurship, financial gain, and some of these values will be in tension with one another. What values will be fostered by the structure of relationships that a given definition of property rights creates? Those are the kinds of questions that will make a difference in the impact that rights actually have.
Thank you. There is a problem with the sound. Hopefully you have had the chance to listen properly what Professor Nedelski said. John.
So I'm not a sociologist or an anthropologist, but certainly there's plenty of anecdotal evidence, in my view, of a culture of growing narcissism and self-indulgence and selfishness. There are certainly well-documented increases in litigation, and as we've heard, there is certainly an explosion of rights claims that have beset the culture over the last 20 or 25 years. And the question is whether those three things are related, whether this new excessive individualism is a consequence of rights, and whether litigation is necessarily a good or a bad thing. And one of the things that I would like to suggest is that it's not necessarily true that a robust regime of human rights leads automatically to individualism and selfishness and the narcissism that we see. After all, historically, both Catholic and Protestant communities in the West were rights cultures in part. And it's not necessarily a bad thing in seasons of cultures to have major campaigns of litigation to get things done. I think the issue is how a culture and how a community finds ways of resolving their disputes, of avenging wrongs, of building relationships, of crediting the reasonable expectation and reliance interests of members of the society. And I think what's emerged in the late 20th and 21st century is the fact that increasingly rights have become the discourse for thinking about how to achieve those forms of dispute resolution, and increasingly without any other universal authority that's respected and recognized, that we turn increasingly and reflexively to the state to get our interests vindicated. And we do that through litigation and lobbying, and increasingly now with deep pockets to be plundered, with insurance companies providing support, and with a massive, massive bar of public interest litigation afoot, the litigation simply escalates as we go forward in time. But I dare say that there are also hopeful signs of change that are, in my view, salutary. Mediation, arbitration, alternative dispute resolutions of various types, defendant-victim reconciliation programs, restorative justice programs are beginning to become increasingly common in different pockets of the West, including in the United States, and these, in my view, have begun to blunt some of these excesses of narcissism and self-interested litigation. Religious communities, schools, neighborhoods, and other institutions of civil society are taking stronger roles at the front end of education, creating prudential norms of interaction with their neighbors, but also at the back end of providing informal but nonetheless effective vehicles of exchange, of resolution of disputes that are before them. Particularly religious communities, the Catholic Church notably has a massive internal religious legal system that is becoming increasingly resilient in its ability not only to deal with high-level official things dealing with the clergy, but also providing a living legal system for the voluntary faithful to turn to in lieu of turning to courts. And in my view, that's a healthy development simply from a public policy standpoint, but it's also a healthy development from a Christian perspective that I happen to come with. Because if we turn to our Bible, we see regularly these admonitions in the New Testament about if you have a grievance with your brother or your sister, go to your brother and sister and seek to work it out. If that doesn't work, bring a friend or two or a member of your community with you. If that doesn't work out, go tell it to the church, we are told. And one of the things that New Testament teaching underscores for us is that we do not have to turn to the state to do all of our hard work of vindicating our interests, of building new relationships with our neighbors, and exercising the love command that we have sometimes requires us to turn the other cheek as well. One interesting quote from the great U.S. Supreme Court Justice Oliver Wendell Holmes, Jr., who said more than 100 years ago, "It's a very sad society indeed that looks to the courts to make all of its hard decisions for it." And I think that admonition 100 years ago, when there wasn't narcissism, there wasn't litigation, there wasn't a human rights explosion at the level that we have today, is one that echoes loudly for us, and I think it encourages us to find alternative ways of living with and loving our neighbors as ourselves.
Let me stress once again one point that I understand is a common point of view of the two speakers. That is, rights per se are not a bad or a good thing. They are shaped according to the cultural background of each society. And we can have individualistic rights that encourage litigation and conflictual relationship, or we can have rights that promote a different culture, provided this culture has already some roots in the society. There is an interaction between the legal tools and the cultural background of each society that can make a different, completely different result with the same legal tools of individualistic rights. So let's turn to a specific question to Jennifer Nedelski. That is rooted in his last book, Laws Relations. In this book, you call for a relational understanding of human rights, which is a strong correction of the general discourse on human rights that is really practiced in our societies. And you start from a rich account of the human person, one that cannot be reduced to the Rawlsian, how do you say that one that is described by John Rawls, a rational agent able to make his own choices. Rationality and free choices are the most important ingredients of a certain kind of rights discourse. On the contrary, you stress the fact that the person is also embodied, is relational, is affected, and rational as well. In Europe, there is an interesting debate in the Catholic scholarship that contrasts the individual considered as an abstract person and the person that is taken with all his richness of his comprehensive experience of the self that include rationality as well as affection, singularity as well as relationality. That is very close to your multi-dimensional self that you describe in your wonderful book. Do you think that this rich understanding of the human person can fit into the right practice as we know it today in our age? Or there is something that is inescapably at odds with him? And if yes, what are the major points that we need to correct in our practice on rights?
Thank you. So I want to have two parts to this answer. First, to say a little bit more about what it means to think about rights in relational terms. And then secondly, to say, well, why are they still really rights when we're thinking about them relationally instead of individualistically? What is it that makes sure that they don't lose their function as rights? So the first thing is to repeat what I said before, that all rights structure relationships. Now, what's important here is that I'm not arguing that that's what rights should do. I see this as just a fact about legal rights. That's what they do. They structure relationships. So, for example, to go back to the issues of property rights and the environment, property rights could include the right to pollute the air from your factory's chimney and dump chemicals in the water that runs through your property. Or we could say, as historically the common law of property did, that the individual rights of property holders are constrained by the rights of other property holders and by collective goods like clean air. So rights can shape relations of responsibility or of power without responsibility. An approach to rights that always asks the question, how is this definition of a right, say of property or of free speech, how is this definition shaping relations? And that then leads to the question, what values are at stake, and what kind of structure of relations will promote the values we really care about? Now, of course, one can do this kind of analysis and consider only values understood in traditionally individualistic terms. One could focus, for example, on the right to do what one wants with one's property, with a minimum of constraints in the name of freedom. Or one can bring in the protection of the vulnerable and the centrality of care to all human flourishing as integral to the very definition of a right. So not in tension and in contrast to be balanced against rights, but built into the meaning of the right. It's important to see that the kind of rights people care about, even from a traditional point of view, require a structure of relations. For example, for free speech to flourish requires a collective culture where people value free expression and encourage it and protect it. No one can enjoy free speech just on their own as an isolated individual. It can only be enjoyed within a structure of relations that fosters it. And most rights really cannot be enjoyed without a supporting structure. Property rights require a widespread respect for the idea of private property. People must accept the relations that private property organizes if property is to be secure. And I think we can see around the world what happens when one sees those relationships of power and hierarchy as no longer justifiable. People aren't going to respect the underpinnings of rights that support that structure of hierarchy. It's also important to see that to ask these questions about relationships and wider values like care is not to abandon the importance of rights to individuals. So this goes to the second question, why are these still rights? To ask these relational questions is not to say that the collective or the community, and certainly not the state, takes precedence over the individual, thus in essence destroying the meaning of individual rights. On the contrary, seeing that rights structure relationships also helps us to see that people cannot enjoy their individual rights without the structure of relationships that enables that enjoyment. So the claim is that the attention to relationship will do a better job of protecting core values like equality and liberty for all individuals by seeing how those values are inseparable from the relationships that sustain them. So the question a relational approach asks are, first, what are the values, such as equality, that we care about? Then, what structures of relations will foster those values? And then finally, what definition of right, of a given right that's at stake, will foster those relations? And I think these questions are completely consistent with existing legal structures. Right now, we can encourage judges, lawyers, and ordinary people to always have these kinds of questions in mind when they think about rights.
Thank you, Jennifer. Let me stress again, once again, your very rich understanding of human experience. You never contrast the individual dimension to the communitarian one or the relational one. You never stress rights, a contrast between rights and care, rights and needs. You always try to bring into the definition of rights all the richness of human experience, which is something very important. Is it feasible? As reflecting on my experience, when you were speaking, I was thinking about the cases that arrive on the bench and deals with rights. I think that there is a big room to taking into consideration the kind of analysis that you propose, what values, what kind of relation, what definition, I would say, because a lot of the meaning of rights is a matter of interpretation. Rights are usually defined in a very essential terms. Everybody has the right to life. Everybody has the right to free speech. And what's the meaning of this right is expounded by judges, which in turn reflect the opinion, the common opinion. So it is a work that calls for the responsibility of everybody, because also in the judicial rooms, we very often have the feeling that we are speaking the voice of the people that, and the culture that is commonly shared in society. So, John, in one of your writings, the production of the books and articles and chapters by John Witt is really very, very impressive. All kind of languages, 15 languages, I suppose. But let's stick to one of your articles and books. You speak about rights, the relationship between rights and religion. In our time, rights proliferate, as we have seen, and this proliferation caused a number of clash of rights. In particular, many of the new rights, such as, for example, reproductive rights, right to die, right to medical assisted procreation, and many others, are in tension with freedom of religion, which is indeed a basic, traditional, important right itself. As a result, in the common opinion, in the public opinion, individual rights and religion are often considered as antagonists. Let's take an example from the recent facts in Paris, the terrorist attack to Charlie Hebdo. Most commentators have described the problem as a conflict between religion and freedom of expression. On the one side, freedom of expression without boundaries, with no limits. Everybody can say whatever he or she wants, even if it offends people. On the other side, religions that become a violent reaction to the freedom of expression. Je suis Charlie Hebdo, the motto that was used in the public in the public demonstration was a kind of expression of this idea. We want to defend freedom with no limits. But some voices have spoken against this understanding and this account. For example, 2 days ago, Pope Francis said we have to preserve freedom of expression, but it does not include the freedom to offend other religions and other people. And even in the New York Times, David Brooks said that hate speech is a limit to freedom of expression. So, what is the reason why you can consider rights and religion as friends rather than as antagonists? And more in detail, what kind of relationship do you figure out for a fruitful coexistence between religion and state-protected rights?
So there's no question that every human right exists in a community of other rights, and every human right, as Professor Nedelsky has underscored, has to be done with sensitivity to the relationship of one has with one's neighbor. And no right is absolute. No right is absolute in the air. Every right has to be balanced by the countervailing concerns of other parties. Religious rights deserve to be protected, but they are not absolute as well. So I start with that premise, and I also start with a basic notion that we need to get past the schoolboy and schoolgirl ideas that we all were taught, that human rights emerged in a post-religious, post-Christian, post-Westphalian settlement, where we finally got over patriarchy and paternalism and abuse and discrimination, and we finally put in place a secular rights regime. And the rights regime that obtains in the 20th and 21st century happily is free from religious taint, and we may or may not grudgingly accord rights of religious freedom, but then those rights of religious freedom must necessarily take a back seat to countervailing rights, as Judge Cartabia's question illustrates. And I'd like to make the argument that religion needs to be a fundamental part of rights conversation, that religious rights need robust protection, not absolute, but nonetheless put on a par with other competing rights claims. And I'd say that for a number of reasons. First of all, without religion, many rights are cut from their roots. The right to religion, Jörg Jelinek, the great German jurist, put it a century ago, is the mother of many other rights. For the religious individual, the right to believe leads ineluctably to the rights to speak, to assemble, to worship, to parent, to educate, to travel, and to do a number of things on the strength of those rights. For the religious association, the right to exist invariably involves the rights to corporate property, to organized structure, to freedom of contract, to freedom of press, to the ability to gather the institutions that are endemic and appropriate to the exercise of that group right. To ignore religious rights is in many ways to cut our rights from their conceptual and, as I said earlier, their historical roots. Secondly, without religion in human rights discourse, many rights become infinitely expandable. Religious communities, Christians amongst them, press rights because of the need to have the freedom to discharge the religious duties of the faith. Rights and duties belong together, and to separate them is in many ways, in the eyes of many religious communities, disastrous. Rights without duties to guide them quickly become claims of self-indulgence, and duties without rights to exercise them quickly become sources of deep guilt. Religious communities, as part of a discourse of right, keep that combination of rights and duties together. Third thing, without religion, the state is often given an exaggerated role to play as the guarantor of human rights. The simple state versus individual dialectic that obtains in modern discourse of human rights leaves it to the state to vindicate rights of every sort. But the reality is the state simply is not and cannot be so omnicompetent as the fantastic failures of the communist experiments of the 20th century underscore for us anew. The reality is that between the state and the individual lie a whole series of mediating structures, intermediate associations we sometimes call them, and religious communities are a critical part of those. And religious communities play a vital role in the realization and the articulation and the defense of first-generation rights of speech and press and assembly. Religious communities provide important and sometimes the only places to vindicate second-generation rights of education and welfare, artistic opportunities, the basic needs of life being furnished. And especially in transitional communities, especially in times of crisis, religious communities often provide zones of liberty, incubators of democracy, to be able to provide, notwithstanding the destruction of the state or the excesses of the state or the tyranny of the state, opportunities for humans to flourish with rights being protected and vindicated. And finally, without religion, human rights have no enduring narratives to ground them. Human rights norms need a human rights culture, and human rights cultures depend upon concrete values to give them real concrete manifestation. We need basic values of restraint and respect, of accountability and responsibility, which religious communities, amongst many others, help to achieve. And so my argument is in part that the human rights regime needs religion in order to survive. Otherwise, it's an abstract set of ideals and norms that simply cannot be vindicated. Now, the particulars of what the tragedies of Paris, the particulars of watching religious communities when they get into the rights regime abusing their rights claim clearly is a danger point with the inclusion of religion as a vital rights player. To give religious communities religious rights is to court the risk of that rights bearer turning those rights into instruments of the destruction of their neighbor. That simply is a limitation that has to be imposed upon the exercise of religious rights. Life and limb, as we have it, are left to the state through our contractarian philosophy to, under due process constraints, take from another. And to equip a religious community with the power over life and limb is in many ways to betray the most fundamental aspects of the division of responsibility that we have. When religious rights clash with countervailing personal rights, the hard part is what the Holy Father said, finding a way of striking the prudential balances and recognizing that the right to operate doesn't necessarily make it the right thing to do in the circumstances. Rights absolutism by religious or non-religious groups alike is dangerous to the polity, and finding a rights culture that makes it inherently impossible for a person to think of that as an appropriate way to exercise her or his rights or their rights as a group, I think is one of the things that we have to strive for.
Thank you. Having heard how much your scholarship so far has contributed to a better understanding of human rights, now I'm very curious about your future projects. What are you working on? What will be your future books, your research that may bring a new fresh air to our reflection on rights or maybe on other topics? Jennifer.
Thank you. So actually my new project leaves the language of rights behind. It's intended to be a really accessible book. Laws Relations was supposed to be an accessible book. My son tells me I didn't quite succeed at that.
It's a big book.
But it isn't meant only for academics, but this next one is really meant to be popular. I'm thinking of calling it Part-Time for All. It's aimed at getting everyone to think about the structure of work and of care that they really want to define their lives. I think we're facing a crisis that arises out of dysfunctional norms of both work and care. And it takes three forms. One is unsustainable stress on families. The second is persistent inequality for women and for the other subordinated groups who are asked to do the care work that make our lives possible and valuable. And the third is that we have policymakers who, by and large, are ignorant about the care that life requires. The people who have lots of experience doing care rarely rise to high positions of power. And those in those positions, or on their way up to them, think it's a waste of their time to do their own care work. So I think these problems require fundamental change in the norms of care and work. My suggestion is everybody engages in paid work at least 12 hours and no more than 30 hours a week. And similarly, everyone, no matter how important you are, no matter how special your skills are, everyone engages in care work at least 12 hours a week, up to 30 hours a week. Now, what I'm talking about are norms, not laws, and not based on rights claims, but about the mutuality of care that is essential to our world. But these norms would be strong norms. So just as today, most adult men would be embarrassed to tell somebody that they'd never held a job. Under my system, if you met an adult man who said that he had never spent much time taking care of others, people would wonder what was wrong with him. And they might suggest something, a group, a doctor, something to help him figure out why he has so misunderstood what matters in life. Right now, it's practically a marker of how important you are that other people do all the care work for you and your family. Under my system, people would no more think about electing a person who was ignorant of the practical demands and rewards of care work than they would elect someone who had never held a job. Both people would be seen as ignorant of core dimensions of human life. So in my short book, I'm going to be arguing that only a radical transformation of how we do our work and our care could solve the problems of our stressed families, persistent inequality, and ignorant policymakers.
Thank you. Very interesting. So, John, what about one of your many projects would you like to speak about? Because I know that there are a number of them.
So there are three things that people will die for: their faith, their freedom, and their family. And that's what I study. I study it historically, I study it comparatively, I study it as a interreligious trope in discussing this with Jews and Christians and Muslims and increasingly Asian religions as well. I do it also as an interdenominational opportunity for deep discussion between Catholics, Protestants, and Orthodox. One of the projects I'm working on is the question of church, state, and the institutions in life where we have spiritual and temporal dimensions that are in constant tension. And there are three big institutions that are at issue. One is the family, the second is the school, and the third is the social welfare institution. Each of them has spiritual and temporal dimensions. Each of them has contested jurisdiction between the church and the state, or religious communities more generally, and political authorities more generally. And each of them now is a deeply contested terrain. And Professor Cartabia's question last time about the tension between religious freedom and sexual liberty is one little area that introduces the whole set of contrasts between the claims that the religious community makes and the political community makes on a fundamental area of sex, marriage, and family life. We are now in the business of trying to renegotiate that as the state's understanding of marriage and family has become thinner and thinner and more plastic. Increasingly, religious communities want out, and they want the freedom to be able to exercise their own semi-autonomy for their voluntary faithful over these fundamental questions of sex, marriage, and family. How much autonomy do we give them? We've negotiated that in the education field over a long period of time. In contested cases from the 19th and the 20th century in America, with the lodestar case of Pierce versus Society of Sisters, ultimately deciding that education of children can be shared between religious communities and the state community. And we now have worked out a public and private education system with licensing controlling what the private educators do. That is an interesting prototype in which to rethink questions of marriage and family and their governance. And then the area of social welfare and charity, we're just beginning with faith-based initiatives and other things to rethink the hermetic wall of separation between church and state that historically obtained in the area of charity, and let these two systems work separately. And the question becomes whether we can renegotiate those boundaries in the 21st century, and trying to figure out what that looks like, both at the theoretical and constitutional level, but then also at the practical level on the ground, is one of the projects.
Thank you, John. Thank you very much. Before concluding this very interesting and enriching conversation, let me stress once again 3 points that I consider common shared proposition of the members of this panel, included myself. First of all, we do not need and we do not want to abandon the rights, the individual rights. They are still the cornerstone of our society, and we want them to continue to be this cornerstone. Nevertheless, second proposition, we need to test rights and right practice continually, an ongoing test, and probably a never-ending test, in order to keep those experiences of right to the real human experience of people as a real and embodied and networked and relational human being, and not as abstract individual, in order to preserve them from becoming a sort of the last utopia. John Whitty reminds us the role of religion in order to preserve rights from the excess of an over-expectation. Rights cannot fill out all they have a limited capacity to fulfill a human expectation. We do not have to run the risk to demand too much from rights. The third point, which was very clear in our conversation, is that there is something beyond law. There is moral norms, there is culture, there is something that shapes also our legislation and our legal culture. For example, I think that all the volunteers here in these rooms are giving a great contribution to a different understanding of our life, and to contrast the selfishness that sometimes is such a risk in our Western society. So thank you, everybody. Thank you to our speaker. Thank you to the organizer.